All right. Hi, all. I am Scott Babwa Brennan, and I am head of online expression policy at the Center on Technology Policy here at UNC Chapel Hill. And thank you so much for joining the conversation today. So, a few weeks ago during the New Hampshire primary, a robocall, which presumably was which employed AI technology to fake President Biden's voice, told voters not to vote in the election, that your vote makes a difference in November, but not this Tuesday. Now, this, of course, wasn't the first example of generative AI that we've seen in political ads or in election content. Last spring, as the GOP primary really got going, we saw a series of examples, some minor, like the DeSantis campaign adding jets, flying behind DeSantis giving a campaign speech, to more significant. Again, the DeSantis campaign released a series of images, fake images of Trump hugging Anthony Fauci. And as we look towards the 2024 election, most agree that we're going to see more examples of generative AI, deceptive generative AI in political ads. So, what should governments be doing to address this? But more importantly, what can governments do given legal limitations, constitutional limitations? And what should they do? What is the right policy here? We are incredibly lucky to have a fantastic panel to help us address these questions. So we're really excited to welcome Commissioner Dara Lindenbaum of the Federal Election Commission, Senator Aaron May Quaid, who represents the 56th District in the Minnesota Senate, and Ari Cohn, Free Speech Counsel at Tech Freedom. Now, I've prepared a series of questions for our panelists, but I will reserve some time at the end for audience Q&A. Feel free to drop questions at any time into the Q&A feature. I'll try to keep an eye on it as we go, but no promises. So I'd like us to start with the risks, the potential harms here. And Commissioner, I'd like to start with you, but I'm going to kind of open this up to all three of y'all. And I guess I'll ask really simply, do you think generative AI poses significant risks to U.S. elections? And if so, what are those risks? What are you most concerned about?
Sure, and thanks for having me. So I'd say yes and no, which is, entirely a legal, answer, but for good reason, I think. So I think on one level, this isn't new. You mentioned the robocall in New Hampshire. Well, I remember back in 2010, there was a robocall in Maryland that used a voice that sounded like Michelle Obama's and said, Governor O'Malley and President Obama have been successful. We're okay, relax, everything's fine. The only thing left to do is watch it on TV tonight. So, that was the immediate thing that popped into my head, was remembering, again, this isn't new, and it's something we have to keep telling ourselves. It's in the news all the time. There's certainly big concerns, but some of this isn't entirely new. At the same time, I'll also add, it's always been very easy to slice up an ad and make it sound like somebody said something they didn't say. A year ago, we had, a mailer that went out and took out of context what somebody said about being pro-choice. So, there's that. But, news travels faster now than it used to, and especially given, the digital tools we have. And that's not just for AI, that's for everything. And misinformation can spread very fast. Micro-targeting makes it even easier for misinformation and disinformation to spread fast, and makes it harder for a campaign or a candidate or a party to correct that misinformation. So before, and well, still now, if somebody puts out a TV ad that is disingenuous, contains misinformation, is wrong, you send a cease and desist to the networks and you try to get that ad down that way. But it's much harder to know about the problem and then tackle it before it's too late. And I think generative AI can also help that kind of information spread, and it can be used for benefit or, negative.
Yeah, that's great. I'm gonna ask about the benefits in a second, but I want us to stay on the risks here and open it up to the other two of y'all. Yeah, what are you most concerned about? Like, what do you think are the biggest risks here?
Hi everybody, I'm Erin May Quaid. I use she, her pronouns. I'm a state senator out of Minnesota. As a policymaker, the biggest concern for me is that we're moving. I mean, yes, AI has been around, for at least 10 years that I've seen it being used publicly. But we're kind of entering into this phase where it's so much easier to use. It requires less resources and less money to do it, and the amount of likeness and photos and voices that are online and for available for people to get, not just of big political figures, but of minor political figures is more than ever before. And we're really entering a phase. And so this isn't just the risks to politics, but to the world, is that we're entering into a place where we are telling people that they can't trust what they're seeing or hearing anymore. And that's a really different world than we're used to living in. Like, we know Photoshop exists, we know those things happen, but you could have an ad where they're saying, Erin May Quaid wants to take everybody's dogs away from them. But now they have the technology to actually make it look like I'm knocking on people's doors and stealing their dogs. That's a new world. And it just creates all sorts of risks, not only to people's trust in institutions and into democracy, but literally in their concept and grasp of reality. And I think that's the thing that terrifies me the most.
I'll admit to being a little bit more bullish than Commissioner Lindenbaum or Senator Quaid. That being said, I think they both make good points, and I think it's important to remember that any tool, any new advancement in technology can be misused just like the old ones. And the deceptive. I was glad to hear Commissioner Lindenbaum talk about deceptive editing before AI, because even things like "you didn't build that," and it's been part of every political campaign since we've had media that can be edited in the first place, or even before edited, just written. So yes, we're going to have bad people misusing technology to do bad things. I don't think anyone can reasonably argue that. The more interesting question is, what we can do about it. But I think for me, if you want the risk that worries me, that is something that actually is kind of towed the line of a little bit by the Biden robocall, and that is use of AI to commit harms to the electoral process, misleading people on things like how to vote and how to register to vote, and things that directly impact the franchise rather than the ultimate decision. And again, that happened before AI. You have the robocalls targeted towards communities in Michigan and New York, towards minority communities that people are actually being prosecuted for at this very moment. But I think that we could do a bit of strengthening in protecting the franchise itself, making sure that the laws that we have do actually apply to the new technology in those particular instances. Because I think for me, people not being able to vote because they were misled about when, where, how to vote is the prime evil, so to speak.
Yeah, absolutely. And you raised, actually, all three of you raised a lot of great points that we're going to come back to, especially on the question of how existing laws do or do not sort of help us out in this situation. But I'm going to do something that I always hate when people do, which is exert moderator's privilege to talk about myself and my own work. So CTP, Center of Tech Policy, we put out a report a couple months ago on broadly on this topic. And we tried to sort of systematically assess the different harms through the existing academic literature. And, we conclude some have been maybe overstated, some have been understated. And the two that I think don't often get as much attention as they should, one of you already mentioned this, which is the harms to down ballot, to smaller campaigns, right, where there's less advertising, less attention, less journalistic coverage. And the second, I see very little kind of discussion of, which is about questions of bias. And it gets to the fact that I think we're going to see certainly some deceptive content, but generative AI made deceptive content. But campaigns are also going to just use these tools in other ways, in more mundane ways. And when they do that, they're going, there's definitely a risk of them bringing in all of the biases that we know that these models have. If they're not very careful in assessing what comes out, right? Like they could be amplifying or replicating these biases. But I think that gets us to this bigger question of just how are campaigns going to be using these tools beyond the deceptive side. And I do feel that we should at least, mention that some people have suggested that there are benefits here. And so, Senator, I want to start with you as our sort of representative politician, campaigner. What do you think of that? Like, do you see a use for these sort of tools in your own campaign? What sort of benefits might they sort of have?
So the benefits that I can think of are small and probably only meaningful to me. So a big one I can think of right off the top of my head is I don't put other people's children's faces on my social media, or, like I go and visit schools, but I take pictures of like our feet together instead of faces, right? That's just not something I'm doing. And so, but a lot of the work I do is in education. So if we wanted to do a mailer or a web ad or something where I'm like doing something with some children, we're reading a book, but they're not real children, right? So that like it shows what we actually do, but it's not using anybody's children, because of later they might not have wanted to consent even if their parents did, right? So like that's something that comes up. Or if it's the day that we're shooting, all of the pictures that we're going to use in the ads, and it happened to be raining, so we can't take any of the outdoor ones, and we're not going to spend the money to get the photographer to come back, so we can superimpose Erin May Quaid in front of the Minnesota Zoo, which is in my district, right? So they're like small ways that I can think of using AI. I have not found it to be useful for anything like writing content yet. It still sounds like a computer. It knows what, but not why. So I haven't found AI to be at this point like far enough along for me to use it in a particularly useful way, other than like maybe some like photoshopping my jacket color. We changed my jacket color between two photos, same picture, different color jacket. That's really, for right now, all I have really seen usefulness. And I'll just candidly admit that I have used ChatGPT to help me brainstorm acronyms for legislation. That is as far as I've got. I've never used any, but it's been good to like throw spaghetti at the wall with ChatGPT, and it got me to where my brain needed to be. Yeah.
I feel like the acronym thing on bills is super important, right? You have to have a really catchy acronym. Commissioner, do you want to weigh in on how you sort of think that campaigns are going to use these sort of tools non-deceptively?
The exciting thing is it's changing, by the minute. And as soon as one starts with one, or, one consulting firm finds a new way, that's how we'll see it. Some of the great ways are possibly translating materials, right? So making sure that your ad can be viewed everywhere. It can also possibly be helpful for election officials, right? As they're making sure that and making things significantly more accessible. However, you still need to have that human who's going to check it and make sure that that translation is right, because it's often wrong or has like small mistakes that actually are quite big. First drafts of things. For smaller campaigns, you said that you haven't quite used it for drafting, but it can be a good first draft. You can punch a few ideas in there and see what comes out, and then someone can take it and work with it and kind of make that into somebody's mind. It can also provide cheap help, possibly if you're trying to figure out, how to put together, a vote model, and you don't have the tools or the ability to hire, a high price pollster. You can, learn, and there's going to be, I'm sure, new software out there from, enterprising folks that you can overcorrect and undercorrect for different communities and different, vote turnouts, and do that in different ways and try to work against the bias and to use it that way. So, that's just the very tip of the iceberg, but there are certainly ways that it can and will be used. And I know I've read a few articles lately about election officials who are starting to use it in their processes. And it can be difficult at the outset, but being open to it can really make it better.
Yeah, Ari, do you want to?
Yeah, I mean, like Senator Quaid, and this is to my great shame, I also have not found ChatGPT useful for writing things, and I refuse to trust it. So that's my Luddite side speaking. But one thing that Commissioner Lindenbaum alluded to is the lessening of expenses for smaller campaigns, and we mentioned the risks to down ballot candidates, but it can also have really good impacts on down ballot candidates, especially in races where there isn't a lot of money floating around in it. The ability to do things like create campaign ads, write first drafts, do things like that without having to hire 80 staffers and figure out how to pay them can actually help level the playing field, even in larger campaigns for federal office. Even it can make the campaign trail more accessible to people who aren't independently wealthy or able to raise bazillions of dollars from family and friends. And that's a net benefit. But there are also two other ways that we've even seen already things happening in positive ways. I forget exactly who it was, but there's the story about the AI virtual assistant that can answer questions about the campaign's positions, the candidates' positions. If somebody calls in or chats the chatbot, and that's great. That not only lessens cost, but it gives more information to more people, and that's never a bad thing. And this one is going to be a little more controversial, but when Eric Adams sent out his calls to various constituencies with his voice speaking in that community's native language, a lot of people were creeped out and said, well, that makes it just sound like he's a polyglot. And point taken, I get it. But that misperception is probably minuscule compared to the feeling of inclusion and belonging in a political system that a community for whom English is not their native language, and that can help them become mobilized and active and think that they should be taking part in the system and making their voice heard because somebody bothered to speak to them in their language. And I think that potential benefit really outweighs any kind of, oh well, he doesn't actually speak all those language concerns. I get the creepy factor, but I'm more interested in how we make people feel like they belong and more readily participate in our political process.
Yeah. Was there a disclaimer on what Adams put
I
out?
don't think so. I can't tell you for sure, but I don't think
that
so.
would have been if I was in a world where I needed to speak multiple languages to many constituents, I only represent 80,000 people. There's only like 4 or 5 languages. But if I wanted to speak like 30, I would probably say like, I'm using AI to translate my voice into your native language. And then I would go on, because it would be so disingenuous to have a whole community of people think I speak your language very, very well. And like, you want to build trust, right, with your elected official. That's not always about agreeing with them, but it's a relationship that's fundamentally built on trust. And so that to me, I just like when you said he did that, I was just like, I would hate that.
Yeah. Cool. All right. Well, let's turn a little bit to the question about what governments are doing here. We're really lucky to have experts who can speak to basically 3 different areas of government action. So, Senator, I want to start with you because states have really been leading the way. We now have at least 5, I probably maybe have lost count, states who have passed laws on AI and political ads, and dozens more just this past month have introduced new legislation. And by my account, counting the proposal seems split into 2 big categories: those requiring disclaimers on new ad content, or excuse me, on generative AI use in political ads, and those choosing to just ban deceptive use entirely. So you, of course, sponsored a bill that was enacted in Minnesota. So I'd love to, so tell us about the bill, and I'd love to hear sort of about your thinking behind it.
So the bill was actually 2 parts. It prohibited the dissemination of non-consensual sexual images or deepfakes. And then it also prohibited the use of deepfake technology to influence an election. We wanted to be very narrow because I see and understand, I'm a millennial, I'm an elderly millennial. I understand technology can and will be very useful in this area. There are 2 places where it just like for us, could not be. And it was in non-consensual sexual images or deepfakes, and then in the elections. And, one of the questions you might be wondering is why not just disclaimers, why ban it? One is that this technology is so unregulated, like completely unregulated. The companies who make it are unregulated, and it's rife with the biases of the people who make it. ChatGPT, for example, scrapes the internet from 2021 and before. I was elected to the Minnesota State Senate in 2022. I'm the first Black woman ever elected to the Minnesota State Senate. So every single thing that ChatGPT would say about the Minnesota Senate would never include a Black woman, right? And so we know that it is just rife with the same biases, and we want people to be able to trust what they're seeing when it comes to elections. I don't think we have the types of regulations and the care and intention with the development of this technology to say like, yeah, we should use it in elections, just put a disclaimer on it. Like there's disclaimers on lots of things. That's not the thing people see. And so it is prohibited within 90 days in an election, meant to influence the election. And so it requires that it's conduct or speech that is so realistic that a reasonable person would believe that it was real, and it relied on substantial technological means to create. So not somebody's, physical or verbal impersonation. To Photoshop obviously is different than that. And in my mind, like we lived for all these years without needing this in elections. I think we can live with that for a lot longer. But I also think that you can't sue your way out of a problem. My first instinct when I look at a problem is not like, how can we make it a crime? That doesn't really solve the problem. This was really meant to be a stopgap until federal legislation passes and there are more regulations, because this is not the solution. This is like a Band-Aid to a problem we saw coming in the 2024 elections.
Great. Okay, we're going to talk about those federal legislation proposals in a minute, but two of the things that really stood out to me in the bill, not to get too far in the weeds, but first, the bill seems quite technology agnostic. Right, the way it's written, it doesn't only apply to AI generated content, but any content manipulated or created through technological means.
Right.
And then the other thing is actually a question. So my understanding is I think it says it criminalizes dissemination of a deep fake. So a person who disseminates a deep fake or enters into a contract or other agreement to disseminate a deep fake. Who do you see as that covering? Does that cover platforms for disseminating, or does that not include kind of intermediaries?
That's a good question. And I think something we're going to come back to this next session is to be really, really clear about who we mean and who we don't mean. So we don't mean news organizations that might show an ad on air that they didn't know was a deep fake and it end up being, it does cover the person who created it and sent it in to the news organization. It also doesn't mean that a news organization that's covering a story about a deep fake that shows part of the deep fake, right, it would be guilty of a crime. And so those are the two distinctions there. And it's specific to a person. And I know corporations can be people under certain parts of law, but because it's a crime, it really is just a person. It's a criminal code. So it is related to a person or people who take part in the dissemination knowing that it was fake. So if you were sent a, deep fake of somebody in an election and you were like, oh my gosh, I had no idea Aaron McQuaid was stealing everybody's dogs. You should see this. And you thought it was real. You also would not be guilty of a crime. So if you retweeted it, or if you, posted it on TikTok or post on Facebook and you didn't know, that would make you, it's the originators that are the targets of the bill.
Okay, that makes a lot of sense. So what else are you planning? So you mentioned that there might be some further action to sort of clarify. What else are you sort of planning?
Yeah,
this year?
we want to make sure that we're really clear about who we're intending and who we're not. I think the bill is just really blanket. I mean, here's the thing. Most people are law abiding, and laws typically provide the guidelines through which we live our life. And so right now, the general understanding in Minnesota by political parties and candidates is that you can't use AI or deep fakes in elections, right? So it just kind of keeps it there. But it is to go back and clarify some of those pieces. There are other parts of election disinformation that exist in the criminal code, and we're looking to see, do we actually need to add this into that? Because there are parts of election misinformation, like if you called people and said the election is Wednesday instead of Tuesday, that is a crime. And then there are a few pieces of the federal bills that we are wondering if we should pull into the state bill, because again, we want it to happen in a timely manner. The federal government doesn't necessarily, or the federal Congress doesn't necessarily move in a timely manner. And so those are some of the pieces that we're thinking of adding in this year. This bill passed 200 votes yes, only one no vote in the entire legislature. So I believe it is almost the most bipartisan bill that we've ever passed about something that wasn't like tax conformity.
Wow, I didn't realize that. That's surprising. So what are some of these like federal proposals that you're interested in drawing in?
Yes, I'm going to pull up my whole other sheet of paper about that. There are there are proposals that are in the federal Congress, and they would allow the exceptions for criticism, satire, or commentary. We removed that on the Senate floor because we weren't sure if we could delineate between, I made this deep fake of Erin McQuaid criticism of her, but it is also like highly inappropriate and not something she ever did, versus something that was made as satire, right? So SNL is a really easy carve out, but something that you make as satire that you share around, not as much. We also have something pulled from, and I'm just going to blank on the bill right now, and I'm so sorry I don't have it in front of me. It's something about watermarking, disclaimers, and then there was a third piece as well that we wanted to look at. Those were the two big pieces that came in that are separate from Minnesota State Code.
Okay, great. Yeah, actually, all right, let's go to you. And I'd love to get your sort of high level sort of summary of some of the big sort of federal pieces of legislation that we've seen discussed, recently.
Yeah, well, they're flying around at a mile a minute these days, but the two primary ones would be a bill that would ban "quote unquote" materially deceptive deepfakes, to shorthand it, in elections at any point in time, and then one that would require labeling of political advertisements that are created with the use of generative AI. Needless to say, I have concerns with both. I think Minnesota's is a touch better than the federal proposals, but there are still some constitutional issues to flag on those. And I don't know if you want me to hold off on that for the moment.
Yeah, we'll come right back to that in a second, because I'm sure. Commissioner Lindenbaum, really quick, I do want to get a sort of update on where the FEC is right now. I know that there's the rulemaking petition filed by was it Public Citizen. I'd love to get the sort of like just what's the status on that. What is the FEC doing right now on this issue?
Sure. So last year, Public Citizen filed a petition for rulemaking, and the FEC has very limited jurisdiction. The only thing that really they could even look at us checking out is our fraudulent misrepresentation statute that is drawn very, very narrowly, and asking us to either clarify that a ad using generative AI would be encompassed in our regulations, or to add language to it to make that. So we put out that petition for rulemaking for comment to see what the comments look like. And when we put it out for comments, what I had said is that I'm not sure if we actually have the jurisdiction to do more, but I hope just through this process of putting it out for comments that we will get just good ideas that can be used by anyone. And I'm really excited that that is actually what happened. We received hundreds of comments, and some of them are from people that never engage with us. They're from organizations that are really on the tech side that have brought so many different ideas to light on ways that it can not necessarily be regulated by the FEC, because many of them didn't actually approach that issue, which of course is huge, but I wouldn't expect them to. Instead, more of the ways that the different companies in Congress can actually create regulations to protect the public, and to move this into an area that can be just helpful. So it's really broad array of comments that are helpful. So we're still going through those and then have to decide our next steps. There are a couple of different things that can be done. Of them, there's, we agreed to start a rulemaking, and we file a notice of proposed rulemaking, receive more comments, start to work on language, things like that. We could dispose of that petition. We could sit on it, which is what the Commission has historically done with petitions for rulemaking, but we're trying not to be that kind of commission anymore. And we can also put out, policy statements and other things like that as a group, hopefully, about how we view our regulations and what it does and does not encompass. So those are all things to think about. I think on the plus side is this, as Senator McQuaid said, this isn't quite a partisan issue because it affects everybody the same. And one of the things that I really thought would be the game changer is how the Republican presidential primary went. And if it was all the candidates kind of attacking each other with generative AI, then that could propel both parties to start working together on this. But I haven't seen that happening. And perhaps that's for the better. But that right now, it doesn't seem like everyone working together to actually find a solution because of that. It's more of a, working around the margins.
Yeah, that's great. So two things to follow up on there. So it sounds like you're suggesting that you believe that the FEC does not actually have the authority really to make kind of meaningful regulation in this space, given the very narrow sort of mandate of the provided by Congress. So I'd love to hear more about that, and if that is the case, it's going to take an act of Congress, right, to expand y'all's authority. What's the chance of that happening?
We'll see. Honestly, so again, I think our regulations, I think, and again, I have 5 other commissioners and I can't speak for them. But the way I viewed it is we have this fraudulent misrepresentation provision. And it was adopted after Nixon ran fake ads saying that Muskie supported the Cuban government, which at the time was very, very bad. In those ads, it was making it sound like that was coming from Muskie and coming from the Muskie campaign. So that is kind of what we're talking about here or exactly what we're talking about here is, if it is one campaign, and again, it's so narrow, our regulations and statute only covers campaign on campaign activity. It doesn't even count, a PAC or a super PAC engaging in this activity. So if one federal candidate creates a ad using generative AI that makes it appear like another candidate is saying something that they didn't say, and they have a disclaimer on it that makes it appear like it's still coming from that other candidate, then that's already going to be covered. That is misrepresenting who is saying what. It's more of now this issue of, well, what if there is a disclaimer? The disclaimer is clear, right? So if it's candidate A has a disclaimer, I usually use Pearl Jam examples here. So if Eddie Vedder for Congress puts out an ad about Stone Gossard for Congress, that makes it appear like Stone is saying something, but it still has Eddie's, paid for by Eddie Vedder for Congress. Well, that's not covered by our regulations. But if Eddie Vedder's campaign puts out an ad with Stone Gossard saying that communism should rule the day, and uses and says it's paid for by Stone Gossard, well, that's already covered by our fraudulent misrepresentation rules.
Right. Yeah. I think this question of how do existing laws sort of deal with this sort of content is absolutely central, and maybe we'll come back to that in a second. But yeah, so really quick though, the second thing you said a few minutes ago was about the possibility of the FEC putting out some sort of policy statement. So say more about that. Is this something that y'all have done regularly? Is this something that you see, like, given the sort of limitations on y'all's authority to regulate in this area, as something that you could do? What might that look like? What's the timeline for that?
Yeah, I mean, I don't like looking at is this something you've done before, because this is a pretty new group of commissioners who function differently than last groups of commissions. So here I would say that we talk a lot more, and we are really having discussions about this and what this means and what we can do. And, of course, it is something that's on, I think, many of our minds. The commissioners put out statements of reasons for different matters, but then they also put out policy statements. Some like to write more than others. I don't particularly enjoy writing. And ChatGPT certainly is not going to help me on this one. It's a matter of really working together on this. But if we do have a sense of agreement on what is covered here, well, then just putting out a statement acknowledging that could just help the public know. I'll also add that we put out legislative recommendations every year. And for the last few years, at least, we have recommended that Congress expand our fraudulent misrepresentation statute so that it covers more than just a federal candidate's action. It also covers other political players or others in the world engaging in this.
Great. Okay. Thanks for that. Okay. So I want to switch a little bit to talking about some of the constitutional issues here of these provisions to get to that sort of what can governments do in this area. And Ari, I want to start with you. And I guess my non-legal, non-lawyerly understanding of the kind of core issue here is that kind of the constitutional issues surround really 2 points. One, do bans or disclaimers constitute content-based restrictions? And then if they do, will they satisfy strict scrutiny? And so I would like to sort of address these 2 questions in turn, and we'll start with the first one. Are these content-based restrictions? If I do not allow a campaign or a political advertiser to use generative AI, is that regulating content? If I require a disclaimer, is that a content-based restriction? Which way does the law point here?
Well, I think that theoretically there could be maybe a way to draft it in a content neutral way. Probably not though, but I haven't seen one that has been because it all. You have to examine the content under all of these proposals to find out whether or not the video or audio or image depicts something that the person who is depicted did not actually say. It's hard to get more content based than that. And there are a lot of issues that come up with regulating political speech in particular. Our First Amendment is, one of its core functions is to protect our self-governance and our ability to discuss political and social issues and to enable us to share the information that allows us to make whatever decisions we end up making. So the courts are really skeptical when they are looking at especially political speech regulations. And we've had a bunch of cases over the past, I don't know, say 3 decades about election-related misinformation. And there are a few through lines. And that is the first is that the government has to prove that there is an actual problem in need of solving here. And I'm kind of like shifting into the second question right now because it's the more nitty-gritty of the 2. And I understand the common sense, of course, argument that this would pose an issue that does need solving. But when you compare it to what we have experienced in elections over the past 80 years in this country of people saying false things and airing ads that contain misimpressions and misinterpretations, I'm not sure that there is a problem that is any greater now than it was back then. And there's the argument that is well taken that it's now more this technology makes it more accessible, more easy to use. But I would also say that all of that additional use isn't necessarily going to be all bad. The proportion of good use to bad use might in fact actually remain the same or even tilt the other way, depending on what people decide to do. So it's really hard to make claims and really like solid legal arguments based on whether there's an actual problem that we need to solve here based on the speculation. I think the courts are going to want a little bit of time to see what has happened instead of what we fear is going to happen, particularly when it comes to election-related speech. And there's another issue of whether or not this actually regulates speech to an appropriate amount, whether it's too under-inclusive, too over-inclusive. And in one sense, the Minnesota bill is actually a little bit better than the federal proposal, which only bans AI use and not, say, the Mitt Romney splicing 2 audio clips, whereas the Minnesota law would tend to cover that. And that's a little bit better in a sense, even though it restricts more speech in that it actually directs itself towards the problem and not this one segment of the problem that leaves a lot of the other problem unaddressed. So credit for that. And I also credit the Minnesota bill a little bit for trying to narrow the time frame. Because one of the key things in a lot of these cases is and the federal bill even is basically from the time that a person announces their candidacy, if you create a deep fake of them that's deceptive, the bill is triggered. And the courts have been very clear that the primary goal has to be to uh, rein in speech that is deceptive and potentially harmful in such a short period of time before an election that there is no chance to meaningfully counter it. And that's the only reason why we're going to subvert the idea that the solution for bad speech is better speech, is because in these very narrow circumstances, there simply isn't enough time. I wonder whether 90 days might be a little bit too long, especially since the sword cuts both ways. Disinformation spreads quicker, but also, the counter speech can spread quicker as well. That being said, 90 days is certainly worlds better than whenever somebody says they're running for office, the law is in effect. And so, that was a wise move. But I think that the downside of the Minnesota law is that it doesn't say anything about materiality. If it was, say 30 days before an election, it's basically just October surprise type things and something that is material. And it's really hard to define that. And I'm not trying to say that this law would be upheld, but it would stand a better chance. But as it stands, there's a famous line from one of these cases that it's a law that makes it just as quote unquote legally harmful to lie about a candidate's shoe size as it does their voting record clearly doesn't make sense and can't be justified under the First Amendment.
Sorry, just to butt in for a second. I'm sorry.
Yeah, please.
I could use a little more.
I'm going off on a rant here.
Oh yeah, no, it's got clarification about what you mean by material. Because my understanding of the Minnesota bill is that it doesn't say meaningfully impacts the election or something like that. So how would adding material, what exactly do you mean? Makes a material difference?
Yeah.
How is that different than what the bill already says?
Well, all speech related to elections is intended to influence the election in some way, shape, or form. That's there has to be something a little bit more than if I say Donald Trump likes his steak overcooked and with ketchup on it, which is true by the way, then that might be a ding to his personal character and tastes and what have you. And I'm certainly intending for people to take that in a way that says I shouldn't vote for that guy. But is that material to a campaign? I'm not entirely sure about that. And like I said, it's really, really hard to discern, which is why writing legislation for this is so fraught with pitfalls. It's hard to determine, and that's we don't know why people vote the way they do all the time. People make decisions that make absolutely no sense based on their stated policy preferences and positions. Voting is a crazy thing that happens for reasons that we don't even ourselves understand when we do it sometimes. So it's really difficult to actually suss that out.
Yeah.
So, and one of the other things is, the level of potential harm it poses. Some of the bills, I think all the bills I've seen so far, don't really make a distinction between something that, say, I send to my mom or a small group of friends and something that airs on national TV. And if we're going to try and draw distinctions between types of harms, I think the latter is maybe more important, and the former should absolutely be excluded from these laws, because me sending some deep fake to 6 friends and saying ha ha ha, that's not something that the government really is. That's not what we're worried about here. Just put it that way.
Senator, I'd love to get your
yeah, I mean, I think there's a few things, right? So when courts apply for any laws that might deal with a constitutional right, that's strict scrutiny, and the test there is it narrowly tailored, for a compelling state interest with no less restrictive law possible. So, I mean, when we made the Minnesota law, the point was to make it narrow, right? It's a narrow time frame, and what we define deep fake is very specific, right? And it's not the Photoshop, it's not adding in clouds or whatever. It is like substantial technological uses that is conduct or speech that somebody did not engage in. And, for speaking as the bill author, I think there is a compelling state interest. There's a compelling government interest, one, to be sure that people can trust their reality. It's this broader issue that I just don't know if we talk about enough. So when we talk about AI and we talk about deep fakes, we talk about specific areas like elections or, non-consensual sexual images or education or healthcare, and they're kind of siloed as if the broader problem itself isn't the same one. I think there's a compelling government interest into people being able to trust what they see and hear. And then there's a second one, which is that, as a public figure, right, as a candidate, people are going to say things about you that aren't true. People are going to say things you did that isn't true, right? But at no point in time have I ever until now been afraid that somebody could make something of me doing the thing that I didn't do and show people that. And I think that individuals have a compelling interest in being able to only be depicted doing the things that they did and said the things that they said. And that's not just for people who are alive, but people who are also no longer living. I don't think we've fully grappled with the way in which people might use people who've been deceased or are deceased and don't have really strong estates in ways that they would never have dreamed that their likeness would have been used. Hubert Humphrey is an esteemed person from Minnesota, and I would love nothing more to be in a political ad where I shake Hubert Humphrey's hand. That never happened, and maybe Hubert Humphrey wouldn't want to be associated with me. So I'm sure he would. But these are all things that I think are compelling enough to regulate in this way. But I do understand, the questions about constitutional rights and questions about speech. I just, there's this thing that always is in my head. I'm but I have a First Amendment right to only say the things that I mean to say and not be saying things I didn't say because somebody else decided to use technology to make me say it. So.
Yeah, and it's tricky. I don't think that a court's necessarily going to buy a compelling interest as broad as right to basically believe what we hear and what we see, because I think the worry there is that opens the door to basically the government gets to decide what's true or not. And I think you'll see a lot of pushback to that. And I also, I do want to pose a counterfactual, because I would also be upset if someone made a deep fake of me saying something ridiculous that I didn't say. So I'm with you on that one. But there was a North Carolina congressional candidate who was complaining of an ad that had a deep fake of him saying words, and he said, "I never said those words." But it turns out, it's true, he never spoke them out loud in that manner, but he actually gave those exact words as an answer to an interview that was then written. They were actually his words. He had never spoken them aloud in that manner, but they were his words that he at one point had said to someone in some form. And trying to divide those two things, because I think if you said it in writing even, and somebody makes a video of you saying it, I think your right to complain about that is slightly diminished, considering the fact that you did actually write those words.
I would agree with you. And I would say that the difference being, if he was going to say it out loud, or she, I'm not sure who it is, that they get to decide the inflection and the tone and the emphasis and the all of the things that come along with speaking that are not there in writing. And so they're again, if I'm imagining an ad, it would be they show my words, right? And they show my picture, or they show me talking at a thing, but I'm muted, and they're showing the words across as if that, they're transcribing it. But I think that if somebody took something that I wrote, which is very different than how I speak, and tried to make it sound like I was saying it, they would get it wrong. They would probably get it wrong. I'm a very emphatic speaker, right? And so you can change the context and the meaning of something that's written with just a sarcastic, yeah, I'm totally for that. Well, yeah, I wrote that, but I meant I'm totally for that, right? So that is, I think that's concerning.
A counterfactual. I love it. And this is why that writing regulations in this area is so incredibly difficult, because there are all of these different circumstances that are really in the breadth of human communication interaction, and the way that we express ourselves is so broad that trying to describe all of these different circumstances in which we do that is challenging, shall we say.
Well, given that, well, first I want to ask Commissioner, do you have anything you want to add to the question of the constitutionality? And then I want to ask about how we move forward, how courts move forward, how are we likely to advance the sort of conversation, like legal sort of like discussion here. But first, Commissioner.
I don't think I have anything to add on the constitutionality aspect. It's a good thing since I'm struggling to say it today. But on the, there's the idea of who's making the decision on when it reaches each level, and what do you do about it? I think that's also one of the key things to think about when we think about regulating is what do we want to accomplish and how? And I know certainly that, if the FEC was empowered to do this under our normal course, we don't deal with things immediately. It's not like, and we can't issue shutdown letter. Like that would mean completely changing the way the commission works if we are somehow able to, issue cease and desists to candidates, campaigns, and digital companies, right? Yeah, candidates can do that at this point, just like they've always been able to do. How receptive some of the social media companies are, that kind of depends on the company, and changing times. But that's kind of one part of it. But then also, should we be the arbiters of if speech is, what level of speech it is, and is it deceptive, and how can it be defended? And is that the best role for, an independent commissioner? I don't know. And we've had some experience in judging, if an ad meets our level of, fraudulent misrepresentation. And in the past, come to some pretty good agreements, but because it was pretty clear and the different ways it was used. If we're talking about the actual content and the truth of the content or how it is developed, that is a much bigger, harder area for a government agency to be dealing with. That said, I think what we're seeing in the states is really what should be happening, which is how states are handling it. And I'm certainly following what's being proposed in different states, what's passing in different states, certainly following what's going on in Minnesota, how the courts are going to handle it, how it's regulated if they're using their, state ethics, campaign ethics agency to determine, what is or is not covered, or what other entities. I think that's where some of these critical components are coming in, and thankfully the states are moving pretty fast, so we're able to see what's happening there. And that is what is almost most comforting to me, is to see that states are taking this, they're thinking, they are working quickly and moving it.
Great. So just a reminder to the audience: drop your questions in the chat. But I do want to, in the meantime, I do want to just kind of follow up on this question of like what happens next. So, do you all expect to see challenges to some of these state laws? Like how is the system going to negotiate out like some of these tricky constitutional questions?
I think we are probably going to see challenges. I think it's just going to come as a part of this wave of the courts grappling with how to apply doctrine to generative AI. I think that's a hot question at the moment, and there's going to be poking and prodding at every angle to see what the contours are. And that's kind of how the law works. That's how we figure these things out in a large way, is by doing things, having them broken, having them struck down or upheld, and creating a body of law around it. That's how it works.
Yeah, just as a lawmaker myself, like there are some laws that you pass and when they get challenged in court, you're like, what? No, it's so humiliating. Or like, I can't believe. And then there's some you're like, yeah, I'm really excited to see what they say. And this is one of those laws. We try to do a really good job of informing people of what the law is as it is right now. And I think Minnesota might be like, we're a really like nice, kind northern people. There might be just less of an appetite for doing some of the things nefariously. And so I don't know if we'll see court cases on this anytime soon. It might be related to maybe a federal candidate instead of being a state-based candidate. But I am interested to see what the courts say and kind of what they how the case law shapes out and what direction we can get from that. What are the boundaries here and what tests should we be applying as we make these laws?
Right. One of the things I wanted to come back to was this question about existing laws that might sort of, or regulations that might sort of apply here. So, we have some states have election misinformation laws on the books in regards to, misrepresentation about the time, manner, place of elections. We have state defamation laws. We have fraud laws. What's y'all's take on the ways in which some of these laws do or do not, and I know that's a big, there's a lot there, but do or do not sort of apply here?
And I can start a little bit and just state that, many of them do apply. And those are the different things that have been used, for, years and years in campaigns, and the defamation laws that, again, it's often be hard to fit one of these cases there. But again, it also moves very slow. So the campaign is going to be over before you get your case through, courts on if you're, an actual case, right? There's going to be, nasty grams that are sent back and forth between campaigns and lawyers in the meantime. And sometimes that makes a dent, but to actually see a case through, that's not going to impact the election there. And for pretty good reasons, government entities can't really issue cease and desists to a campaign for the content of their ads. So, it's spotty, but maybe that spottiness is okay.
Scott, you're muted.
Thanks. That's embarrassing. The others, y'all want to jump in on this question? But this is probably the last, going to be the last question for us. So, final thoughts.
Just the one thing I wanted to add is that, in Minnesota, for example, in our election law, there are a few election-related crimes, bribery, and specific things that if you violate those parts of the law, then you forfeit your nomination or your office. And so I think one of the things we'll be grappling with in Minnesota is, do we add in deep fake to influence an election to that? I don't know. I generally don't like making more things crimes and removing duly elected people from office and all of those things. But we have a whole set of things that prohibit you from holding the office or the nomination if you do them. And so grappling with whether this would be included in that. And that's a fun question for this legislative session.
Great. Well, I think we're gonna. Ari, was there?
Yeah, no, I think I agree largely. I think there are many laws that plausibly cover, at least at the margins, certain of these actions, and that is part of what we are seeing right now, just in general civil litigation about where the contours of those things are. And I think it warrants a careful, watchful eye over the next few years to see what the problems expose themselves to be and whether or not we have solutions to deal with them or whether we can at all. So we're very much in a wait and see period in time.
Great. That's a great place to end. But thank you all so much. This has been fascinating, and we really appreciate you taking the time to join us. And for those in the audience, Center on Tech Policy, we do these sort of conversations a lot, pretty regularly. So keep an eye on our materials, and we'll hope to see you soon.